present, ready to proceed.
Yes, Your Honor.
Defense present, ready to proceed.
Yes, Your Honor.
Any matters we need to take up from the state before we proceed to opening statements?
Yes, Your Honor. Good morning.
I know I'm interrupting, I appreciate that. Is the defense going to have any matters to take up also?
We will, Your Honor.
Now, thank you, appreciate your patience.
Good morning, Your Honor. My name is Kate Hollowell, and I'm joined by my co-counsel Derek Kim
Good morning, Your Honor.
Morning.
and Allison Townsend.
Good morning, Your Honor.
Morning. I have a bad habit of interrupting, I apologize.
No worries.
We represent the state of Midlands in today's case. Would Your Honor like us to continue into housekeeping matters now, or have the defense introduce themselves first?
Let's see what the defense has, and then I'll circle back to you.
Hello, Your Honor. My name is Lauren Smith, and I'm accompanied by my co-counsel.
Hello, my name is Christina Wisniewski.
Hello, Your Honor. My name is Dave Gromick.
Morning.
And we proudly represent the defense in this case of Charlie Martin, who is here at the table with us today.
Hello, Your Honor.
Good
I'm
morning.
Miss Charlie Martin.
Okay, you going to have any matters to bring up?
We will, Your Honor.
All right. Go ahead and grab a seat, we'll let the state go first since they have the burden.
Yes, Your Honor.
What do you got?
May we assume that all witnesses have been constructively sworn in,
Yes, you may.
and that all witnesses have been constructively sequestered, other than party representatives, which include Charlie Martin and investigator Taryn Rivera in this case?
Are you asking the bench to invoke the order of sequestration?
Yes, Your Honor.
Defense have anything to say about that?
No, Your Honor. That is our understanding as well.
It is so done and it is constructive.
May we move freely about the well?
You may move freely about the well. I would appreciate it if you would ask prior to approaching witnesses. And I understand that all sidebars are constructive, but let me know when you're going to do that too. Other than that, yeah, move freely around the courtroom.
Yes, Your Honor. May we assume that all objection arguments are constructively heard outside the presence of the jury?
Yeah, let's do that. In general, not all objections need to be heard outside the presence, but for purposes of trial, that's what we'll do, yeah.
May we assume that all sustained objections are automatically stricken from the record?
You may not. If you want it stricken, you need to ask.
Yes, Your Honor. Your Honor, at this time, we would like to provide you with a bench book, which includes a clean copy of all relevant case files, including stipulations and case law.
Appreciate that. You may approach. Thank you.
Now, directing your attention to stipulations 10 and 11, which are under the yellow tab in that black bench book. We would like the record to reflect that all objections have been waived to the admissibility of exhibits 9 through 13 and 21. And exhibits 1, 8, 17, and 22 have been pre-admitted as evidence.
I doubt seriously I'll be able to keep up with all of that as we proceed, but if I come off the rails, please feel free to respectfully correct me.
Yes, Your Honor. And finally, Your Honor, the state would like to bring to your attention that we will make use of various demonstrative aids, including the use of redacted exhibits throughout this trial. Opposing counsel was informed of this during captain's meeting, and they had no objections.
Is that the case?
It is, Your Honor.
Thank you. I'm not insinuating that you're not being truthful. I'm just giving everybody a chance to be heard.
Finally, Your Honor, the state is ready to proceed.
You brought up the matter of demonstrative aids. If a demonstrative aid is I noticed you've got tripods over in the corner, and I assume you're going to be using those. Please, I know it's awkward, but please make every effort that I can see them too. But the jury comes first, want them to be able to see it. Opposing counsel for both sides, if the other side is using demonstrative, you need to reposition yourself so you can see it. You don't need to ask permission, just get up and quietly scurry across the courtroom and do what you need to do. But I want to make sure that everybody can see, okay? And if you can't see, let me know.
Yes, Your Honor.
Is that all?
Yes, at this time, the state is ready to proceed.
Defense.
Yes, Your Honor. One more housekeeping matter. The defense would like to ask, where would you like witnesses to direct their testimony, to the bench or to the jury box?
Jury box.
Yes, Your Honor.
Good question, thank you.
And the defense would like to direct your attention to motions in limine. We believe that's the orange tab in the bench book.
Orange tab in the bench book. Yes, I see.
Specifically, we'd like to direct your attention to motions in limine letter E. This just states that along with Dr. Michael Lynn, Taylor Jaw is also an expert in this case that can be called. She is an expert in reality TV. To tender her as an expert, prongs 702A, B, and C have already been satisfied. It is 702D that we would have to show to you today in court.
Okay, is that correct?
Yes, Your Honor, that's our understanding.
It is my understanding that all motions in limine have already been dealt with. We won't be hearing any oral motions in limine, is that correct?
Yes, Your Honor.
That is correct, Your Honor.
Thank you. Anything else?
Yes, Your Honor, I'd like to direct you to the case law tab. I believe that is the red tab.
Okay.
Specifically to page 4, State v. Durden. This just states that we cannot use temporary insanity as a defense in this case. However, we can use temporarily insane mindsets as relevant information to the jury.
I assume that if either side runs afoul of that rule, but I'll be hearing an objection.
Yes, Your Honor.
Yes, Your Honor.
And I emphasize that because it is the responsibility of the parties to bring these things to the court's attention and to make the appropriate objection at the appropriate time, so keep that in the back of your mind.
Yes, Your Honor.
Anything else?
No, Your Honor. With that, that concludes our pretrial orders. We are ready to proceed with opening statements.
Unless I hear something differently, I assume we are ready to proceed to opening statements. Does the state wish to have an opening?
Yes, Your Honor, may I proceed?
At your convenience.
Thank you, Your Honor. The price of pride was a life. It's April 6th, 2025, and Rob Armstrong woke up with $1 million dream. After 2 grueling months competing on season 2 of the reality show, The Saboteurs, today was the final challenge. Rob woke up, got ready for the day, treaded down to the lagoon where the final challenge would end. Then he cleared his medical check. And then he did an interview, and then he set up his position at the challenge entrance. Rob was the favorite to win this challenge, and in just a few hours, he knew that he'd be one step closer to that $1 million dream. The final challenge begins. Rob powers through the obstacle course, sprints down to the lagoon, puts on a scuba mask, but then something's not right. When he puts on the scuba mask, he rips it immediately off, and he coughs. For 10 seconds, he's standing there coughing. Now, Mr. Armstrong doesn't just stop the challenge there. He keeps going. He pushes through. And he puts the mask back on and dives back into the lagoon. Now, for the first few minutes, everything is fine. Rob had to untie 5 rings from metal anchors underwater, and he'd already gotten through 3. But after that 3rd anchor, Rob starts to struggle. His movements get slower. He's becoming frantic and desperate. And just after 10 minutes in the water, he is the only contestant still down there, despite being the first one that went underwater. 4 more minutes go by, and Rob is still struggling, still underwater. He's going frantic and desperate, and he yanks off his mask and flails around and convulses, and then his eyes shut. His body goes still. Robert Armstrong's dream doesn't end in triumph. It ends in silence. That is the price of pride. The price of the defendant's pride. You will learn that on April 6th, the defendant had their own dream in mind. Revenge. The defendant, well, they were a contestant on the show too. This wasn't their first rodeo with Rob Armstrong. You see, back 5 years ago, they were contestants on an earlier season of the show. And Rob betrayed the defendant. The defendant was costed $1 million and her pride. The humiliation from the betrayal was replayed on screens and in public for years. So, the defendant, before even getting into season 10, made her plan and picked her poison. Oxalic acid, a common cleaner, but when inhaled, a deadly poison. And she put that deadly poison in Rob's scuba mask, and he inhaled it, and it caused him to drown, which happened to be the inevitable death of Rob Armstrong. As a state, we have the burden to prove beyond a reasonable doubt that the defendant caused Mr. Armstrong's death and that she intended to do so. And we will show you today that we will meet that burden and we will leave no reasonable doubt. You'll hear about the years of humiliation that the defendant suffered for 5 years. Rowan Patel, an employee of the show, has known Rob and the defendant since that betrayal. And she'll tell you that when the defendant came back to season 2, all she talked about was getting revenge. And she'll also tell you that she saw the morning of the challenge, the defendant put something in a scuba mask. The defendant had a plan. Investigator Taryn Rivera will come forward with her investigation. She'll tell you that the defendant saved a warning label detailing the dangers of oxalic acid well before the season even started. And she'll tell you that during an interrogation by the police, the defendant literally admitted to putting that poison in Rob's scuba mask. She got her revenge. Oxalic acid was inhaled by Rob, and it caused him to rip it off and drown. The chief medical examiner for Midlands, Dr. Atlas Hartley, will come forward and tell you that the medical signs point to one conclusion: oxalic acid poisoning. The price of pride. At the end of trial today, my co-counsel Ellison Townsend will come before you and tell you that the price of the defendant's pride was Mr. Armstrong's life. And she'll tell you that even though the defendant got her revenge, she must pay the price for her actions. We ask you to find Charlie Martin guilty. Thank you.
Yes?
Yes, Your Honor. May it please the court. Blinded by love, betrayed by trust. On April 6, 2025, an individual by the name of Rob Armstrong passed away on the set of a reality TV show known as The Saboteurs. It is his death that brings us all here today. But as you're going to learn, this is not a case about a cold-blooded murder. This is a case about a young woman who made a mistake. Not because she wanted to take lives, simply because she was blinded by love and betrayed by trust. Now, you're going to hear that Charlie Martin came back to season 10 of The Saboteurs. Of course, again, like I said, not to kill, simply to prove herself after the embarrassment she suffered on season 2. She came to show the world she was more than the loser they made her out to be. But most importantly, as you're going to hear, Charlie Martin came back to make Riley Kay proud. And towards that end, when Riley Kay told Charlie what to do, well, Charlie listened. Why? Because Charlie was blinded by love. Now, today you're going to hear about Riley Kay, the story creator, the producer. She had control of everything behind the scenes, and as you're going to hear today, she especially had control of Charlie. You're going to learn that Riley Kay was furious about the embarrassment that Charlie suffered. She was furious. She wanted justice for the woman she loved. So when the opportunity came on season 10 to put the spotlight back on Charlie, to make her look strong, clever, worthy of winning, well, she took that opportunity. And Charlie went right along with it. You're going to hear how Riley Kay pushed and pushed for Charlie to increase her sabotages against Rob Armstrong, saying that it had to be done, that Rob must be eliminated. And Charlie, never believing that the woman that she loved would go so far to suggest something unsafe, well, she followed Riley Kay's lead. Followed her lead all the way up to the events that killed Rob Armstrong. You're going to hear how Charlie Martin put her trust, her faith into Riley Kay. And quite unfortunately, she was betrayed by that trust. We are all here today because the prosecution is bringing the charge of murder against Charlie Martin. Now, I would like to remind you, they hold the burden of proof in this case. They alone must prove to you beyond a reasonable doubt that Charlie Martin intentionally murdered Rob Armstrong. Now, we as the defense, well, we hold no such burden. Nonetheless, we will show you evidence. We'll bring you Taylor Jaw, an expert in reality TV, who will show you how emotionally manipulative reality TV shows, or more specifically, reality TV show producers can be. And then you'll hear about the impact of that manipulation on the mind of a young woman so deeply in love. From Dr. Michael Lynn, a clinical psychologist who spent hours examining Charlie. And finally, you're going to hear from Charlie herself. And she will tell you how every single one of her actions since joining the cast of the Saboteurs has been, in one way or another, influenced by Riley Kay. After hearing from these three witnesses and considering all other evidence that we will show you today, we will be clear that Charlie Martin was blinded by love and betrayed by trust. That she's not a cold-blooded murderer. She's a hopeless romantic. At that time, my co-counsel, Mr. Gromek, will come before you and ask that you find Charlie Martin not guilty. Thank you.
State, call your first witness.
The state calls Rowan Patel to the stand. May we proceed, Your Honor?
Please.
Good morning. Please state your name for the record, spelling out your last.
Good morning. My name is Rowan Patel. That's Patel.
And how are you involved in today's case?
I was there when Rob Armstrong was killed on set of The Saboteurs.
And why were you on set?
I was the show's challenge designer. We were filming our final episode.
What was Rob doing on set?
He was one of the contestants competing in the challenges.
Well, before we talk about that day, I want to rewind back and talk a little bit more about the Saboteurs. What kind of show was it?
It's a reality TV show.
And could you explain the premise of the show?
Yes, so it's basically a combination of the games Clue and Werewolf. We had 20 contestants from all different walks of life in a remote location competing together against each other, in various challenges. If you finished last in a challenge or you were voted off by the other contestants, you went home. But what made our show special was the Saboteurs.
Who were the Saboteurs?
They were the contestants that we would pick secretly to stir up drama and make it harder for the contestants to complete the challenges.
And Ms. Patel, how did a contestant win?
Well, when there were about 2 or 3 contestants left, the competition would end. If none of those people were saboteurs, then they would split the prize money. But if there was even one saboteur left, that saboteur would get all of the money.
How much was the grand prize?
It was $1 million.
Well, let's move on and talk about season 10 in specific. You mentioned that Rob died in season 10. Where was this?
It was here in Charlotte County, Midlands.
And did season 10 have a special theme?
Yes, it did. It was our all-star season. We brought back fan favorites from the past 9 seasons.
Since Rob was a contestant, does that mean he's been on the show before?
Yes, he was actually the winner of season 2.
For season 10, did you guys bring up any of the other contestants from season 2?
Yes, Charlie Martin and Jonathan Hubbard were also there.
Is Charlie Martin sitting in the courtroom today?
Yes, she is.
Could you identify them with a piece of clothing?
Yes, she's wearing that gray sweater.
Let the record reflect that the witness has identified the defendants.
Shall so reflect.
Let's rewind back to season 2. Why did the defendant and Mr. Armstrong get invited back for season 10?
because they have one of the biggest rivalries in reality TV history.
How did that rivalry start?
Well, back in season 2, they were both saboteurs, and they had just spent the entire season working together to split the grand prize. But with only 5 people left, Rob convinced everybody that Charlie was the last saboteur. And it worked. Charlie was eliminated in the final challenge. It was one of the greatest moments in reality TV history. Rob left with $1 million. Our show became a hit, and Charlie left with nothing.
Ms. Patel, how, if at all, did this rivalry impact season 10?
Charlie was constantly trying to make things harder for Rob.
And how did she do that?
She personally targeted Rob 3 times, which is half of season 10's sabotages.
Was the defendant a saboteur?
Yes, she was, just like in season 2.
Well, what about Mr. Armstrong?
No, he was not like he was in season 2.
Ms. Patel, how long ago was season 2's betrayal?
It was back in 2020, so 5 years ago.
Well, let's shift forward in time now to the day that Mr. Armstrong died. When was this?
April 6th, 2025.
And what happened on April 6th?
It was the day of the final episode and the season finale, final challenge.
What was this final challenge about?
We called it Sink or Swim. They had an obstacle course that they had to do with weighted backpacks, followed by a scuba diving segment.
Did Mr. Armstrong make it to this point?
Yes, he did, and Charlie was the last saboteur.
Was this, you mentioned that the defendant sabotaged Mr. Armstrong many times. Was this challenge one of those times?
Yes, it was.
Well, to your knowledge, what was the sabotage supposed to be?
Charlie was just supposed to add an extra 10 pounds of weight to Rob's backpack.
So, before that challenge, did you see the defendant do anything at all?
Yes, I saw Charlie earlier that morning with the scuba equipment. She told me she needed to check out the equipment one more time, and then I'm fairly certain I saw her add some white powder to one of the masks.
Well, Ms. Patel, throughout the entirety of season 10, did the defendant ever talk about Mr. Armstrong?
Yes, all the time, honestly. Almost every conversation went back to Rob.
And what were these conversations about?
Revenge, constantly. I mean, even when revenge wasn't relevant to the conversation.
Ms. Patel, do you remember the first time you remember the defendant talking about revenge on season 10?
Yes, it was at the beginning of the season in an interview that was conducted by our show host.
And how did that conversation go?
At the end of it, Charlie said, "Revenge is a dish best served cold."
Nothing further, Your Honor.
Cross-examine.
Yes, Your Honor. Well, Mrs. Patel, I want to start by talking about those backpacks you mentioned. So, after Rob Armstrong's death, you examined the entire challenge grounds, right?
Yes.
And you examined those weighted backpacks, right?
Yes.
Now, a part of your challenge design, all of those backpacks start with 10 pounds weight, right?
Yes, that's true.
And part of your design, as a sabotage, someone could add an extra 10 pounds weight, right?
Yes, that's what Charlie's sabotage was.
Yeah, and you examined Rob Armstrong's backpack, right?
Yes, that's right. I examined all of them.
So, based on the sabotage, the maximum number of weights could only be 20, right?
Yes.
But when you looked in Mr. Armstrong's backpack, you didn't find 10 or 20 pounds of weight, did you?
No, I didn't.
No, you found 30 pounds of weight, 3 times the starting weight.
Yes.
No, you are aware of Riley K, aren't you?
Yes.
No, it's Riley K's responsibility to ensure the sabotages happen as they should, right?
Yes, that is her job.
If the sabotage happened as it should, there should not be 30 pounds of weight in Rob Armstrong's bag, should there?
Yes, that's true.
So Riley Kay did not fulfill her responsibility to ensure the sabotage happened safely.
Objection, Your Honor. Lack of foundation.
Please say it, counsel.
The defense would want prosecution to clarify what foundation has not been laid.
Yes, Your Honor. Opposing counsel hasn't clarified what and was not the responsibility of Riley Kay. They talked about how making sure the grounds of the challenge are part of the responsibility, but there hasn't been foundation laid that Riley Kay specifically did not fulfill her responsibility.
May I respond, Your Honor?
Go ahead and respond.
I just asked this witness if it was the responsibility of Riley Kay to ensure that sabotage happened properly. We have laid the foundation that it is her job. The sabotage did not happen properly, and therefore Riley Kay did not satisfy her job of ensuring that it happened properly.
I'm sure the jury can separate it out. Overruled.
Yes, Your Honor.
Allow me to re-ask that question. Riley Kay did not satisfy her job in ensuring that that sabotage happened properly, right?
I suppose so, yes.
Now I'm gonna bring you a little bit backwards to before that challenge started. You conduct wellness checks on every contestant, right?
Yes, I do.
One of these contestants is Rob Armstrong, right?
Yes.
In fact, Rob Armstrong was the only one out of all contestants to mention something being wrong with him, right?
Yes.
Yeah, he told you he was sleep deprived.
Objection, Your Honor. Hearsay.
Counsel?
Your Honor, this would go to the effect on the listener. It's Rowan Patel's job to ensure that from hearing these reports from the contestants to make the decision of whether or not they can or cannot compete in the challenge. That would go to Rowan Patel's later decision to allow Rob Armstrong to compete in the challenge. It's not whether or not Rob Armstrong actually was exhausted. That's not the defense's contention.
Your objection will give you the last say.
Sorry, could you
It's
repeat
your
that?
objection, so I will give you the final say. Anything else to add?
Yes, Your Honor. If this isn't for the truth of the matter, then I would object to relevance as to it being important to establish sleep loss by Mr. Armstrong.
Overruled. Let's proceed.
Allow me to re-ask that question. Rob Armstrong told you he was sleep deprived, right?
Yes.
He told you he was suffering from allergies, right?
Yes, he did.
He told you he was exhausted, right?
Yes, but I mean, all the contestants were.
It wasn't my question. He told you he was exhausted, right?
Yes, I said yes, but all of the contestants were also exhausted.
Despite the fact that he was exhausted, sleep deprived, suffering from allergies, you cleared him to complete the challenge anyway.
Yes, he told me he was alright to compete. So.
Rowan Patel, you're Miss Patel, right? You're not Dr. Patel?
Yes, but I've been doing this for years. I know what contestants who are able to compete look like and who the contestants who are not able to compete look like.
Miss Patel, that wasn't my question. You're not a doctor, correct?
That's correct.
You never went to medical school, right?
No, but I didn't need to for that part of my job.
You would agree. You don't have any medical basis to make these opinions, right?
No, I just have the basis that I've used for the past 9 seasons.
Which is not a medical one, you would agree.
I would agree, but I don't need a medical one.
Now, Ms. Patel, I want to speak to you about what happened after this challenge. Let's bring you to the present. The Saboteurs has been canceled, hasn't it?
Yes.
And as such, you have lost your job.
Unfortunately, I have.
And you've received a lot of backlash from the fans of the Saboteurs, right?
Yes.
Yes, they blame you for Rob Armstrong's death, isn't that right?
They try to, but I know it's not my fault.
Yeah, you know it's not your fault. In fact, you think it's Charlie's fault, right?
She may have something to do with it.
Yeah, you blame Charlie, right?
Objection, Your Honor. Asked and answered.
Got her on cross. I'll give her a little leeway.
Yes, Your Honor.
Overruled.
You blame Charlie, right?
Yes, I would say I wouldn't be here right now if it weren't for Charlie.
Yeah, in fact, you believe that if Charlie were convicted, you might get your job back, right?
That's a possibility, yes.
Yeah, Charlie Martin was convicted, people would stop hating you, right?
Yes.
No, you're here today testifying against Charlie Martin, right?
Yes, I am.
Thank you. No further questions, Your Honor.
Any redirect?
No redirect, Your Honor. I just asked that this witness be excused.
You are excused. Call your next witness.
The state calls investigator Taryn Rivera to the stand.
and name for the record, spelling your last.
Good morning. My name is Taryn Rivera, Rivera.
What do you do for a living, Investigator Rivera?
For the past 2 years, I've been an investigator with the Federal Trade Commission, and before that, my home for 10 years was with the FBI's Fraud and White Collar Crimes Division.
How are you involved in today's case?
I was the lead investigator and the arresting officer in the death of Mr. Rob Armstrong.
Can you tell us where Mr. Armstrong passed away?
Yes, it was here in Charlotte County, Midlands, at the Hotel Lux specifically.
Who did you arrest?
I arrested Charlie Martin.
Is Charlie Martin in the courtroom today?
Yes, she is.
Can you please identify the defendant based on an article of clothing?
She's there in that gray sweater.
Your Honor, let the record reflect that Investigator Rivera has identified the defendant.
The record shall so reflect.
All right, now, Investigator Rivera, can you tell us when you first got involved in this case?
Well, last spring, I went undercover on the saboteurs to investigate a separate matter, and after Mr. Armstrong died, I revealed my identity to local law enforcement, and I launched an investigation.
During that investigation, did you ever uncover any text messages?
Yes, I recovered 2 sets, one from the defendant's personal phone, and the other from Riley Kay's phone. She was the story producer.
Would you recognize screenshots of those text messages if I were to show them to you today?
Yes, I would.
Your Honor, let the record reflect that I'm retrieving exhibits 18A, C, and D, as well as exhibits 19B and C. I have pre-prepared redacted copies of these exhibits. Like we mentioned in pre-trial matters, I showed them to opposing counsel during captain's meeting and they had no objection. So let the
Sullivan
record,
during the meeting?
Yes, Your Honor.
If we can, I'm not insinuating you're not being truthful, I'm just covering all parties.
of course, Your Honor. Let the record reflect I am giving opposing counsel 1 copy of this redacted exhibit. Would Your Honor like a courtesy copy as well in case we need to argue an objection?
Yeah, thank you.
And may I approach the witness with a clean copy for identification purposes?
Yes, ma'am.
Thank you.
All right, Investigator Rivera, starting with exhibits 18A, C, and D, what are these collectively?
These are screenshots of various text conversations from the defendant's personal phone.
Have they been changed or altered in any way?
No, they have not.
All right, flipping to exhibits 19B and C, what are these?
These are screenshots from Riley Kay's phone of conversations between her and the defendant who was texting on a dumb phone. You can see that it's the defendant because the contact at the top says Martin.
How do you know that the defendant was texting from a dumb phone?
During my investigation, I learned that Riley Kay had purchased the defendant this dumb phone, and these were the only text messages sent or received from it.
And have these messages been changed or altered in any way?
No, they have not.
Your Honor, at this time, the state moves to enter exhibits 18A, C, and D, as well as exhibits 19B and C into evidence.
Any objections?
No objection, Your Honor.
They're in.
Your Honor, permission to publish a redacted version of these exhibits to the jury?
Any problem with that?
No problem whatsoever, Your
Go
Honor.
right ahead.
Here you go. All right, Investigator Rivera, starting with exhibit 18A, who's the defendant talking to here?
Riley Kay, the story producer for the saboteurs.
Can you tell us what those two talk about?
This was right after the cast list for season 10 had gotten leaked, and after claiming that everyone on the internet was talking about it, the defendant says, "I'm not letting this happen again. I won't be the joke this time. He'll die before I let that happen."
No object, Your Honor, to needlessly cumulative. This is already in evidence. The witness does not need a reading onto the record as well.
Your Honor, if I may, the rule that opposing counsel is referencing is Rule 403, which states that cumulative evidence must significantly outweigh the probative value. Here, Investigator Rivera reading this onto the record for the jury to better understand has probative value, and it is not in any way significantly outweighed by cumulative evidence. It hasn't even been mentioned on the record.
Response, Mr. Rouse?
Hang on, I'll give you your chance.
Yes, Your Honor.
Just give you a little bit more about why the evidence, the probative value is not substantially outweighed by the prejudicial effect.
Of course, Your Honor, may I proffer?
Sure.
So these text messages will serve to form a timeline where it will show that the defendant refused to come back for season 10 of the Saboteurs. But then Rob Armstrong texted the defendant, antagonizing her. And about an hour later, she's then agrees to be on the show
And the evidence later will also show that she saved the material safety data sheet for oxalic acid to her phone right after Rob Armstrong texted her. This goes directly to the defendant's intent to murder Rob Armstrong, which is a key part of our case, of the prosecution's case today.
Your objection, you get the last one.
Yes, Your Honor. While the witness can use this document to add context, they don't need to explicitly read out every single text message. They can add that context while referencing the content, but not just blatantly repeating it for the jury.
Your objection is well taken, but I don't really see any problem with it. I think that 403 allows this to come in, so it's overruled.
Yes, Your Honor.
Yes, Your Honor. I'll ask you that question again, Investigator Rivera. When were these messages in Exhibit 18A sent?
These were sent on January 5th at 10:29 p.m. It was about 4 weeks before the contestants arrived on set for filming.
All right, and flipping over now to Exhibit 18C, what can you tell us about these messages?
These are text messages sent to the defendant from Mr. Armstrong. They say, in case you forget, I win, you lose. That's how it works. I can't wait for the internet to go off on you after you humiliate yourself all over again. The popcorn is already popping itself.
And what time did Mr. Armstrong send these messages?
These were sent on January 7th at 11:30 p.m. It was a few days after that cast list had gotten leaked.
All right, and now for Exhibit 18D. What can you tell us about these messages?
These are text messages between the defendant and Riley Kay. It's essentially just the defendant agreeing to be on season 10 of The Saboteurs.
And what date and time did the defendant agree to be on season 10 of The Saboteurs?
January 8th at 11:15 a.m. It was that next morning after Mr. Armstrong texted her.
All right, and flipping over now to Exhibit 19B. What can you tell us about these?
This is the defendant asking Riley Kay where the cleaning supplies are, specifically the chemicals. She says she has a plan and sends 3 separate messages saying please. Riley Kay then tells her to check the basement.
And what time were these sent?
March 29th at 1:05 a.m. It was a few days before the episode 8 challenge was filmed.
All right, and closing out these text messages with Exhibit 19C, what can you tell us about these?
The defendant says that she's going to stop Mr. Armstrong in the next challenge, that she is done doing sabotages the right way, and that it's time for something stronger.
And what time were these messages sent?
These were sent on April 1st at 11:49 p.m. This was 5 days before the final challenge and Mr. Armstrong's death.
Investigator Rivera, do you know if text messages were the only thing recovered from the defendant's personal phone?
No, I also recovered a PDF document that had been saved to her phone.
Would you recognize a screenshot of that PDF if I were to show it to you today?
Yes, I would.
Your Honor, let the record reflect that I am retrieving what has previously been marked as Exhibit 14
Record shall so reflect.
and showing it to opposing counsel. May I approach the witness with the same?
Yes, ma'am.
Thank you.
All right, Investigator Rivera, is this the PDF that was saved to the defendant's phone?
Yes, it is.
Has it been changed or altered in any way?
No, it has not.
Your Honor, at this time, the state moves to enter Exhibit 14 into evidence.
Any objections?
Yes, Your Honor, specifically to hearsay.
Your Honor, may I respond?
Always.
Your Honor, we're not offering this exhibit for the truth of the matter asserted, to show that oxalic acid was dangerous. We're calling an expert witness to the stand later to prove that. Rather, this exhibit is going to the effect on the listener, specifically the fact that Ms. Martin saw this document, knew it was dangerous, and then decided to use it against Mr. Armstrong during season 10 of The Saboteurs.
Your objection, last word.
Yes, Your Honor. The state cannot prove that Ms. Martin actually read this document. In fact, if I may proffer, Ms. Martin will come up here and tell you she's never read it in her life. Therefore, they can't prove effect on the listener, and if they're not using it for the truth value, then this document isn't relevant to today's case.
Your Honor, may I respond?
And then I'm going to rule.
Yes, Your Honor. Your Honor, what opposing counsel just said goes to the weight and not the admissibility of this document. The evidence will show that this was saved to the defendant's phone, which has probative value in this case in proving intent. Whether or not the defendant testifies to reading it goes to the weight of this document, not the admissibility.
You'll have her on cross in a minute. Overruled.
Yes, Your Honor.
Your Honor, may we assume that this exhibit has been entered into evidence?
Yes, thank you for catching me on that. You're entitled to a ruling. First off, the objection is overruled, and secondly, it's admitted.
May I publish this exhibit to the jury?
Yes,
And would Your Honor like a courtesy copy as
I
well?
would, thank you.
Here, Your Honor.
Thank you.
Investigator Rivera, what exactly is this document?
This is a Midland safety data sheet that outlines the dangers of oxalic acid.
Do you know what time it was saved to the defendant's phone?
Yes, the metadata confirms that it was saved at 9:46 a.m. on January 8th. This was the morning after Mr. Armstrong had texted the defendant, and about an hour or so before she agreed to be on season 10 of The Saboteurs.
Now, Investigator Rivera, do you know if the defendant was interviewed by law enforcement during this investigation?
Yes, she was, and I've reviewed the transcript of her interrogation.
Do you know if she was ever asked about oxalic acid?
Yes, she was.
What did the defendant say about oxalic acid?
Well, like Rowan Patel testified before me, the contestants had to wear a scuba mask in the final challenge, and the defendant admitted to putting oxalic acid onto Mr. Armstrong's scuba mask.
Thank you, Investigator Rivera. Your Honor, I have no further questions at this time.
Suzanne?
Yes, Your
Archie
Honor.
has exhibits for me. Thank you.
Now, I'd like to start with a couple of things you said on direct, specifically that data sheet, okay? You can't prove that Miss Martin read that sheet, right?
No, I cannot, but it was downloaded to her phone.
Exactly, you can only say it was downloaded to your phone, so you can't say that Miss Martin knew the contents of the sheet.
I cannot say that for certain.
You can't tell us Miss Martin knew the dangers of oxalic acid.
No, I cannot.
We'll move on. So, Investigator Rivera, you are aware of what the Communications Act is, right?
Yes, I am.
It's an act designed to protect contestants on game shows from producer manipulation.
Yes, it is.
And that's
Objection, Your Honor. Relevance.
Your Honor, pursuant to Rule 104B, may I conditionally admit this testimony on the grounds that I prove its relevance in a subsequent question?
Let's reverse that. I'm going to give you an opportunity to lay a further foundation, but I'm not going to make a decision on tendering or excluding until I hear both arguments in full.
Yes, Your Honor.
So, hold off, please lay a little bit more foundation and we'll go from there.
Yes,
Yes,
Your
Your
Honor. You actually received 50 complaints, over 50 complaints, about the saboteurs having production manipulation, right?
Yes, we did.
And that's actually why you were on the show, right?
Yes, I was investigating that.
Because production manipulation is a violation of the Communications Act.
Yes, it is. It is a federal crime.
Well, when you arrived on set, you actually met one of the producers, right?
Yes, I did.
You attended a pre-production meeting with Riley Kay,
Yes, I did.
the executive story producer.
Yes.
And in that meeting, Riley Kay actually said something that really stood out to you, right?
Yes, she did.
She said that Miss Martin was a safe bet to win season 10.
Objection, Your Honor, as to hearsay, and I would also like to restate my objection as to relevance. I still don't see how the Communication Act is relevant here.
Break it up, down, counsel, for me. Take up the hearsay first and then the relevance objection.
Yes, Your Honor, we're using this for the effect on the listener, specifically the subsequent actions of Investigator Rivera. If I may proffer.
Yes, but I would like you, if you would, to proffer as to what you expect the subsequent action to be.
Yes, Your Honor, specifically that Ms. Rivera found it suspicious and looked into Riley Kay over the course of her investigation because of it.
So, tell me a little bit about the relevance of that then.
The relevance of the Communications Act?
Is that your objection?
Yes, Your Honor, I was restating the objection that I made previously.
Okay, yeah.
Your Honor, we just laid foundation that the Communications Act and complaints about violations of the Communications Act was the reason that Investigator Rivera was on set in the first place.
Your objection, last word.
Yes, Your Honor, the Communications Act is a violation about producer manipulation, about rigging the outcome of the game show. That has nothing to do with our charge of murder in today's case, and for the exact reason that opposing counsel said his testimony was relevant, means that he's offering this hearsay statement for the truth of the matter asserted to prove that Rivera was there for that reason. And I still don't see how the Communications Act in rigging the outcome of a game show is relevant to a charge of murder.
Close call, but I'm going to overrule it. You proceed.
Yes, Your
Yes,
Honor.
Your Honor.
I'm gonna re-ask you the question. Miss Riley Kay said that Miss Martin was a safe bet to win season 10 of the Saboteurs, right?
Yes, she did.
Now, you found that a little suspicious, right?
Yes, of course I did.
Because that statement goes to a possible predetermined winner, right?
Yes, it does.
An executive producer saying specifically that she thought Miss Martin, a contestant who's never won this competition before, was a safe bet over everyone else.
Yes, that's correct.
Well, the next time you saw Miss Kay, she was actually talking to Miss Martin, right?
Yes, she was.
And she handed Miss Martin a piece of paper.
That is correct.
Well, that next challenge was a trivia challenge, was it not?
Yes, it was.
Miss Martin won.
She did.
Miss Martin, in fact, got every single answer right.
She did.
Now, you do not know what was on the paper that the producer, Riley Kay, handed to Miss Martin, right?
No, I do not.
But if it had the answers to that trivia challenge, that would be a violation of the Communications Act.
Objection, Your Honor. Against relevance. May I be heard?
You may give me 1 second to finish your note, okay?
Of
If I
course.
don't do it now, I'll forget.
Of course.
Appreciate your patience, counsel. The forum's yours.
Your Honor, under Rule 401, relevant evidence must go to prove or disprove a material fact in today's case. The charge today is murder. It has nothing to do with rigging the outcome of a game show. So opposing counsel asking these questions again and again about Miss Martin winning a challenge has nothing to do with either proving or disproving that she is guilty of murder in today's case.
Your Honor, it's defense's entire contention today that Riley Kay manipulated both the game show and Charlie Martin to end up with Rob Armstrong's death. Relevance is a very low bar in the state of Midlands, and this absolutely makes a fact of the case more or less probable. Therefore, it is relevant.
Yeah, I know I said you get the last word last time, but this time I mean it. Okay, your objection, last word.
Yes, Your Honor, again, it has to be a material fact. And Ms. Kay rigging the outcome of a trivia challenge has nothing to do with her rigging the outcome of Mr. Armstrong's death. If that's opposing counsel's intention, I ask that he focus his questions on whether or not Ms. Kay truly manipulated Mrs. Martin to kill Mr. Armstrong. A trivia challenge, again, is not a material fact in proving or disproving that she is guilty of murder.
Materiality is indeed a low bar, so I'm going to overrule it and admit the testimony.
Yes, Your Honor.
Yes, Your Honor.
I'm going to re-ask you the question. Now, if that piece of paper had the answers to that trivia challenge, that would be a violation of the Communications Act, right?
Yes, it would.
The entire reason you were there in the first place?
That is correct.
All right, I'd like to move on to the last time you saw Riley Kay. It was on the day of Rob Armstrong's death, right?
Yes, it was.
And when you arrived to the scene of Rob Armstrong's death, local police arrived soon thereafter, right?
Yes, they did.
And they asked you where the production control center was, right?
They did, yes.
You showed them the way.
I did.
And when you got there, you found Riley Kay dumping buckets of water on the hard drives that contained the footage from the challenges.
That is correct. I did see that.
Almost all of that evidence was destroyed.
Yes, it was.
So you caught Riley Kay tampering with evidence.
Yes, I did.
You arrested her on the spot.
I did.
And that's when you became the lead investigator, right?
Yes, it is.
You called your boss,
Yes, I did.
and your boss told you to collect as much evidence as possible, right?
That is correct.
Well, let's talk about the evidence he actually collected. Now, a lead investigator on a potential murder case would typically shut down the crime scene, right?
Yes, depends on the situation.
Collect evidence from the crime scene.
Yes.
Interview witnesses at the crime scene.
Yes.
Well, you didn't do any of that.
No, I didn't suspect that there was foul play until after the autopsy had been conducted, and it was found that oxalic acid was the cause of Mr. Armstrong's death.
So you didn't suspect that something more contributed to Rob Armstrong's death?
No.
Now, that's your affidavit, right?
Yes, it is.
If you would flip to the back for me.
Okay?
That's your signature on the back, right?
Yes, it is.
One moment. If I could direct your attention to page 7, line 212. If you can read in your head as I read aloud. Kay had water buckets and was pouring it over what looked like servers. At this point, I began to strongly suspect that something more may have contributed to Rob Armstrong's death.
If you turn to page 10, it says, line 293, because I did not identify any signs of foul play in Armstrong's death until after the medical examiner's autopsy, we did not search Hotel Lux.
Well, the question I just asked you is whether or not you suspected something more had contributed to Armstrong's death at the time, right?
Yes.
Well, you didn't shut down the crime scene, right? You didn't shut down the place where a man had just died.
No, I did not.
You didn't even shut down the hotel.
No, I did not.
In fact, you only came back to the hotel 2 days later, right?
Yes, that is correct.
After you got the autopsy and toxicology report.
That is correct.
And by that time, production had packed up and left.
Yes, they did.
Which means you lost a lot of valuable evidence.
Yes.
In fact, I want to talk to you about why you didn't do a lot of these things. You've never been on a murder investigation before in your life.
No, I was in the fraud and white collar crimes division of the FBI.
You don't have a single bit of experience with violent crime.
No.
And not once have you investigated a case with oxalic acid.
No, I have not.
No further questions, Your Honor.
Can you redirect?
No, Your Honor. May my witness step down from the stand?
Yes. Your next witness.
The state calls Dr. Atlas Hartley to the stand. Your Honor, permission to prepare the well for demonstrative release later during the direct.
Sure. Thompson, do you need the evidence back you gave me?
You're free to keep it until the end of the trial, Your Honor.
Ah, thanks.
Your Honor, permission to proceed? Good morning. Could you please state your name for the jury, spelling your last?
My name is Dr. Atlas Hartley, Hartley.
Are you currently employed, Dr. Hartley?
Yes, I have been Charlotte County's Chief Medical Examiner for the last 5 years.
What do you do as Chief Medical Examiner?
I mainly conduct autopsies in suspicious death cases.
And is this your first time testifying in court?
No, I've testified as an expert witness in the field of forensic pathology around 60 or so times.
What kind of schooling did it take to become Chief Medical Examiner?
Ooh, it was a lot. I got my Bachelor of Science in Archaeology and Forensic Science at the University of Central Florida. I then got my MD at the University of South Florida. After that, I did postgraduate training at the Michigan School of Medicine, and then I did my residency at the Wake Forest Baptist Medical Center.
How are you involved in today's case specifically?
I conducted the autopsy on Rob Armstrong, the victim in today's case.
Did you reach a conclusion as to the cause of Mr. Armstrong's death?
Yes, I did.
What facts and data did you rely on informing your conclusion?
I relied on Mr. Armstrong's medical records, the footage from the dive where he drowned, and my findings from the autopsy and toxicological analysis that I conducted.
Were those facts and data sufficient?
Yes, they were.
And what principles and methods did you apply in reaching your conclusion?
I used the standards set forth by the National Association for Medical Examiners. It's been extensively peer-reviewed and is considered the gold standard in my field. I've used them throughout my entire career.
Are those principles and methods reliable?
Very, yes they are.
And did you reliably apply those principles and methods in this case?
Yes, I did.
Dr. Hartley, what conclusion did you reach as to the cause of Mr. Armstrong's death?
The cause of death in this case was drowning induced by oxalic acid poisoning.
what is oxalic acid?
It's a cleaning agent similar to bleach. It looks like a white powder.
Why do you believe oxalic acid contributed to Mr. Armstrong's death?
Well, for one, I'm quite familiar with how poisonings contribute to the human deaths. I actually helped develop the protocols for rare poison detection in Charlotte County. In this case specifically, I ran a toxicological analysis on various tissue and blood samples from Mr. Armstrong's body.
Which parts of Mr. Armstrong's body?
His mouth, bronchi, trachea, and his kidneys.
Did you record the results of your analysis?
I did.
And did you write a report based on the autopsy you performed?
Yes.
Let's start with the autopsy report. How were you able to determine that Mr. Armstrong inhaled oxalic acid?
Well, there were multiple small abrasions in and around his mouth, consistent with chemical burns. His bronchi and trachea showed signs of redness and rawness, which is consistent with having inhaled oxalic acid.
To be clear, Dr. Hartley, is it your belief that Mr. Armstrong inhaled oxalic acid before he died?
Yes.
How could you tell?
Well, there were no signs of oxalic acid in his stomach or esophagus. However, there was a high concentration of it in his blood vessels, which supply oxygenated blood throughout the body.
Now, turning your attention to the toxicological analysis, were you able to determine how much oxalic acid Mr. Armstrong inhaled?
Yes, I was.
How much?
Up to 1.75 grams.
Is that amount considered dangerous?
Absolutely. It's 3 times what's medically safe.
And how would inhaling that amount of oxalic acid affect Mr. Armstrong?
It would have caused him to suffer from hypoxia 4 to 6 minutes after diving underwater.
Well, what is hypoxia?
It's the deprivation of oxygen to the body prior to death.
What are the symptoms of hypoxia?
Visual disorientation, apparent weakness, and rash decision making.
Now, Dr. Hartley, you said earlier that you reviewed the footage of Mr. Armstrong drowning. Let's talk about what you saw. Your Honor, permission for my witness to step down for demonstrative purposes?
Problem with that?
No, Your Honor.
Right ahead. Yeah, you guys, gonna say you need to reposition yourself, even yes.
Yes, Your Honor.
Dr. Hartley, when Mr. Armstrong first entered the water, what condition was he in?
So for the first 3 minutes or so, he was breathing heavy. That was just due to exertion, but it stabilized. Overall, his movements and his breathing were normal.
What happened next?
Around the 4.5 minute mark, his swimming began to slow and his movements became a little less fluid. He started showing signs of confusion and weakness, which is the onset of hypoxia.
Once hypoxia started setting in, what happened? Dr. Hartley, let me ask you that question again. Once hypoxia set in, what happened?
He began swimming around, confused. He seemed to make motions that made no sense. Over time, he was drifting between anchors, and his motions just were confused.
Did Mr. Armstrong ever attempt to swim to the surface?
Yes, after about 12 minutes or so, he attempted to rapidly ascend. However, he stopped and then began descending erratically. At that time, he took off his mask, inhaled water, began convulsing, and was unconscious after a matter of seconds.
Thank you, Dr. Hartley. You may return to the stand. Based on your training and experience, are these behaviors consistent with hypoxia caused by oxalic acid poisoning?
Yes, they are. The factors of consciousness and the buildup of it are all signs of hypoxia induced by oxalic acid.
In your expert opinion, would Mr. Armstrong have died without inhaling oxalic acid?
No, his physical fitness level and lack of prior medical issues renders it severely unlikely that he would have experienced hypoxia or died without the presence of oxalic acid.
No further questions, Your Honor. Would opposing counsel like me to deconstruct the demonstrative?
You can leave it up.
Permission to preserve it?
Well, by preserve it, are you asking opposing counsel not to mark on it?
Yes, Your Honor.
Do I need to mark on it?
No.
Okay.
Crossmark. Dr. Hartley, you just told us a lot about what you did for the case, but I want to first talk a little bit more about you.
Okay.
Now, you're a medical examiner, right?
Yes, I've been the chief medical examiner for the last 5 years.
You're not an investigator.
No.
It's not your job to investigate criminal cases.
No, I conduct autopsies and focus on the medical aspect of it.
It's not your job to talk to defendants in criminal cases.
No.
You can't tell us what Miss Martin was thinking when she put that oxalic acid into the mask.
No.
You can't tell us anything about her mental state.
No.
You can't tell us anything about her intent.
No. I mean, I don't see how that directly contributes to whether or not oxalic acid was involved in it, though.
Because you've never talked to Miss Martin yourself.
Objection, relevance.
Your Honor, there's a very, very low bar for relevance in Midlands. But further, we're just clarifying that although this witness can state that oxalic acid is the cause of death, he can't help the prosecution, meet any other parts of their burden in today's case.
Your objection, last word.
Your Honor, this is an expert witness who specializes in conducting autopsies in suspicious death cases. It's not relevant whether or not he's had conversations with the defendant or can testify to the defendant's mental state.
I think on cross-examination, I can see some relevance. Overruled.
Yes, Your Honor.
Dr. Hartley, I want to move on. During your examination, you reviewed what was a material safety data sheet, correct?
Yes, I did.
And you would recognize that data sheet if I were to show it to you today?
Yes, I would.
Let the record reflect that I'm retrieving Exhibit 14, and I'm showing it with you.
Shall so reflect. Gotta give me a chance to rule.
Oh, sorry.
The record shall so reflect.
Apologies. Thank you, Your Honor. Permission to approach the witness?
Yeah, go ahead.
This is a copy of that data sheet, correct?
Yes, it is.
Dr. Hartley, I want to direct your attention to lines 11 to 14, the inhalation section of this data sheet. Nowhere in these 3 lines does it say the words fatal, correct?
That is true.
Nowhere in these 3 lines does it say the word lethal, correct?
That is true.
So an average lay person wouldn't know that oxalic acid is lethal if they just had access to this data sheet.
That is correct.
Thank you, Dr. Hartley. I'd like to move on to the day of April 6th. The day of Mr. Armstrong's death. You received a call from the governor, correct?
I did indeed.
And the governor himself asked you to perform the autopsy of Mr. Armstrong.
Yes.
And after receiving this call, you immediately went to the set of the saboteurs.
That is correct.
When you were on set with the saboteurs, you met with story producer, Miss Riley Kay.
I did.
You then had a conversation about what supposedly had happened that day, correct?
Correct.
You talked about the safety procedures on set.
Yes.
You talked about what could have contributed to Mr. Armstrong's death.
Yes.
And then you talked about the safety divers on set.
That is correct.
But when you asked Miss Kay about anything relevant to the divers, she was extremely vague with her answers, correct?
Yes.
She can't tell you the time frame of when it took the divers to enter the water.
That is correct.
She couldn't tell you why it took the divers so long to enter the water.
That is also correct.
But despite her vagueness, you were able to review some footage later on your own to see the time that the divers entered the water.
I did.
And you took some notes regarding that footage.
Yes,
And you would recognize those notes if I were to show them to you today.
I would.
May the record reflect that I'm retrieving Exhibit 5.
Shall so reflect.
It may reflect that I'm approaching opposing counsel with Exhibit 5.
Yes.
Permission to approach the witness, Your Honor?
Yes, ma'am.
Dr. Hartley, this is a copy of those notes, correct?
It is.
I want us to walk through these notes from the time that Mr. Armstrong entered the water to the time that he exited.
Okay.
At the beginning, Mr. Armstrong is completing the challenge.
Objection, hearsay.
Let's let counsel finish the question, and then we'll see where we're going.
Yes, Your Honor.
Your Honor, I'm confused as to what they're objecting to. Could they clarify?
That's why I asked counsel to let you finish your question.
Oh, okay. At the time for Mr. Armstrong starting to complete the challenge, he's completing it relatively easily, correct?
Yes, we will.
Steve, I'm sorry, I apologize for objecting. You were beginning to ask a question, and counsel objected as to hearsay, but you didn't get a chance to finish is that the question you were going to ask before the objection?
Yeah, that he was completing it easily at the beginning.
Okay.
Your Honor, I asked that opposing counsel admit the exhibit before they begin talking about it.
Sustained, it's a relevant objection.
Yes. Your Honor, under Rule 705, we believe that he can discuss it regardless, but we would like to offer Exhibit 5 for evidence just
How
for the
would
jury.
how would the rule allow you to effectively reveal to the jury what the evidence is before you tender it into evidence?
Your Honor, our understanding of Rule 705 is that experts can talk about documents that would have otherwise been in evidence that aren't admitted prior, but we are more than willing to enter Exhibit 5 into evidence right now.
Let's get the last word on the objecting
Your
counsel.
Honor, I believe that Rule 703 is what allows previously inadmissible statements to be used in an expert's testimony. Rule 705 that they mentioned is that experts may be led on foundational matters.
I'm going to overrule the objection, but I enjoyed the give and take on the rules.
Yes, Your Honor.
Your Honor, for clarity, the defense now enters Exhibit 5 into evidence.
Any objection?
Yes, Your Honor, to hearsay.
Your Honor, first, Rule 703 is clear that this was used for an expert witness to help prepare their opinion, but secondly, it's also a record of reflection and a present sense impression.
Your objection, last word.
Your Honor, they have not laid the foundation that it's a recorded recollection.
May I respond? We just asked the witness that he wrote these notes as he was watching the video footage, and it is a record of recollection of what exactly has happened, and both of the parties have agreed that it's accurate prior to coming to court here today.
I contradicted myself again, so I'm going to really give you the last word this time, then I'm going to rule.
Your Honor, I don't believe that they asked Dr. Harley that question.
In the absence of a court reporter, which would make this an easy call, I'm going to overrule the objection and let's proceed.
Yes, Your Honor.
All right, Dr. Hartley, just to clarify, you wrote these notes after watching that footage, correct?
Yes, I did.
And these notes accurately reflect everything that was in that footage?
To the best of my ability, yes.
So let's now walk through that footage step by step. Mr. Armstrong first enters the challenge and is completing everything easily, correct?
Yes.
Until about the 4-minute and 30-second mark, he's flying through this challenge.
He was going very quick, that is correct.
But then at 5 minutes and 30 seconds, something abrupt happens.
Yes.
His pace starts to slow noticeably.
Yes.
There are erratic patterns of breathing.
Yes.
And you know there are erratic patterns of breathing because the entire video footage is filled with bursts of bubbles from Mr. Armstrong's mask.
Yes.
And for 45 whole seconds at this point, Mr. Armstrong makes no progress on the challenge.
No.
But there are still no divers in this water.
That is correct.
Moving forward to 2 more minutes, this moving patterns worsen, correct?
Yes,
They start become more dysregulated.
they do.
It's now clear that they are no longer purposeful.
That is correct.
The movements are no longer purposeful, but there are still no divers, the 7-minute mark.
That is correct.
And moving on, Mr. Armstrong actually makes an attempt to surface, just like how you said on direct.
He does. He tries to come up, but then ends up coming back down.
He traverses 25 vertical feet,
That is correct.
and then he starts descending rapidly.
Yes.
But as he's descending, he's in this awkward tilted position.
Yes.
His head starts moving side to side.
Yes.
He's now falling in circles,
That is correct.
but there are still no divers in the water.
That is correct.
Now, I want to move on to the 14-minute and 30-second mark. Up until this point, Mr. Armstrong is just progressively getting worse and worse, correct?
That is correct.
Mr. Armstrong makes 2 full attempts to surface,
Yes.
but no divers.
Correct.
Because at 14 minutes and 30 seconds, Mr. Armstrong, then and only then, begins to start tugging at his mask.
He does.
He's tugging at his mask for a whole minute and 30 seconds.
Yes.
And there are no divers in this water.
That is correct.
Then Mr. Armstrong is successful in ripping off his mask.
Yes.
But the divers don't come into the water immediately.
They do not.
Mr. Armstrong is inhaling water for a whole 30 seconds after he takes off that mask.
That is correct.
Because it takes the divers a whole minute to enter the water after Mr. Armstrong takes off that mask.
Yes.
And before the 15-minute and 30-second mark, there is no trace of any safety precautions on this video footage.
That would be correct.
No further questions, Dr. Hartley. Thank you.
Redirect.
Brief redirect, Your Honor.
You got it.
May I retrieve the exhibit, Your Honor?
Sure.
Your Honor, permission to approach with Exhibit 14.
Yes, ma'am. Now, refresh my memory a little bit, Counsel. Was that one of the ones that was pre-admitted?
Yes, Your
I
Honor.
appreciate that.
Dr. Hartley, directing your attention to lines 18, does it say anything about being possibly fatal?
Yes, it does. At the very end, it says possibly fatal.
Now directing your attention to line 24, does it say anything about seeking medical attention?
Yes. Again, at the very end, it says seek immediate medical attention.
No further questions, Your Honor.
Recross?
Yes, Your Honor.
May I retrieve the exhibit?
Sure.
You could leave the exhibit if you
Oh.
like. Dr. Hartley, line 18 under possibly fatal is under the section of ingestion of oxalic acid, correct?
That is correct.
But Mr. Armstrong didn't ingest oxalic acid?
Mr. Armstrong inhaled the
Exactly.
oxalic acid.
Mr. Armstrong inhaled oxalic acid. And under lines 11 to 14, the inhalation section of this exhibit, the word fatal and lethal don't appear, correct?
Those two words do not appear. That is correct.
Nothing further, Your Honor.
May the witness be excused?
Yes, Your Honor. I ask that my witness be able to step down.
Thank you, Mr. Witness. State by next witness.
The state rests.
Anything we need to take up before the defense has the opportunity to present a case?
No, Your Honors.
Anything from the defense before you guys have an opportunity?
No, Your Honor.
All right, it is now close enough to 10:30 for me to call it exactly 10:30. Let's take a 5-minute break. 5 minutes.